just in case you needed a quick refresher on the limits of self-defense, we got one for you. What's up, everyone out there in YouTube world, Facebook world, social media world, the world, musings of MGL, coming at you with a sober reminder of what limitations apply to self-defense and when you can use a firearm to defend yourself and when you can't. So a question I get all the time are hypotheticals. Well, what if somebody's doing this? What if somebody's doing that? What if somebody's coming here? What if the person's this? What if the person's that? When can I shoot? When can I not shoot? Those are very difficult to answer because every single case relies on the facts of that particular case. There is no blanket rule of when you can use it and when you can't, despite what the statutes say, and people can argue and says, well, it says this, it says that. The fact of the matter is every case is different. Every sheriff is different. Every prosecutor is different. Every judge is different. So you can't just lay out specifics of when you can and can't use it. However, we can look to cases that have existed and what happened in those cases and see what the verdicts were, what the sentences were, what prosecutors did, just to kind of give you some parameters of maybe when you can use it, when you can't. And here's a common question that I get all the time. It has to do with your house and the castle doctrine. A lot of people ask, well, do I have to wait for them to come into my house? What if they're outside my house? Can I shoot them on the porch? Can I shoot them through the door? Can I shoot them if they're crawling through the window, but they haven't yet made it all the way into the house yet? Again, those are all very fact-specific cases. We do have one that recently came out, though, that's kind of making the rounds that everybody's talking about that has some implications in it that might answer some of your questions. And let's get into it. Let's just see what the facts are and see if we can find out where this person went wrong. So, it's a very famous case. It just kind of came out. It's making all the rounds. I pulled this article from People, but it's all over, CNN, Fox News. It's everywhere. It happens to be here in Florida, in Ocala. And I'll just go through the facts of the case, and then we'll talk about it. So a Florida woman fatally shot a black neighbor after complaining about her kids playing outside, found guilty. Now, of course, this article and a lot of the articles play up the race factor of it. It was a white woman who shot a black woman. You're going to see some allegations in here that she called the black woman's kids the N-word. I'm not going to get into all that kind of stuff. It certainly doesn't help the defendant out to have done those things and for it to be portrayed that way. But I'm just going to look at it as the legal facts of what the parties did here physically and whether that amounted to use of self-defense justifiable or not. So Susan Lorenzik, the white woman who shot her black neighbor, again, they have to put race in there because that's just what the media does. But the white woman who shot the black neighbor through her front door after complaining about their neighbor's children playing outside has been found guilty of manslaughter. Jurors in Marion County, Florida, found her guilty of manslaughter by use of a firearm after a week-long trial that resulted in the death of Ajiki A.J. Owens, according to a news release of the 5th Judicial Circuit State Attorney's Office. The shooting happened on June 2nd, 2023, after Lorenz claimed Owens' kids were trespassing on her Ocala property. And one of the children allegedly threatened to beat her up, according to the 911 call on the day of the incident, which was reviewed by People. According to the arrest affidavit, the Marion County Sheriff's Office said that over the past several years, Lorenz had become angry at Owens' children who would often play in a field close to her home. In an interview with police, she admitted to having used the N-word towards children out of her anger in the past and also to calling children other derogatory terms. Authorities previously said that on the evening of the shooting, Lorenz got in an argument with the children and threw a roller skate at one of the 10-year-olds, striking him in the toe, and later swung an umbrella at another son. After learning of this, Owens, the victim, accompanied by her 10-year-old son, approached Lawrence's home, the affidavit said. Owens had knocked on Lawrence's door multiple times and demanded that Lawrence come outside. Lawrence then fired one shot through the door, striking Owens in her upper chest. Lawrence claimed that she acted in self-defense, according to authorities, and that Owens tried to break down her door prior to the shooting. Lawrence also claims that Owens had come after her in the past and had previously attacked her. During the investigation, authorities spoke to neighbors who reported that Lawrence was constantly harassing the children for playing near her home. One neighbor claimed to officers that Lawrence called in false reports on them. The sheriffs later determined that Lorenza's actions were not justifiable under the Florida law. So she was charged with manslaughter, and the jury convicted her. So let's break this down. Again, setting aside all the racial stuff, because I'm only going to look at it from strictly a self-defense, gun lawyer, criminal defense standpoint. I get this question all the time. Do I have to wait for the person to come into my home to shoot them? Like, let's say I'm in my house and I've got my young children in the home, and there are people clearly trying to break down my door to come in my home. Why do I have to wait for them to break down the door and come into my house before I can use self-defense? Can't I shoot them through the door or shoot them out of a window? I get that question all the time. What I'm going to tell you, and what most defense attorneys are going to tell you, yeah, as crazy as that may sound, you're probably going to have to wait until they come into the house, because you are going to have a hard time articulating that you are in imminent fear of death or great bodily harm since they're not in your home. Remember, the castle doctrine basically applies to when they come into your house. There's a presumption that if they come into your home, they're only coming into your home without your permission to commit a crime and violence against you, and the castle doctrine kicks in, et cetera, et cetera. You can use deadly force. Now, I have in the past said that I would still, I wouldn't just shoot any person who climbed through my window just because they climbed through my window. I would still want to make sure it wasn't some, drunk teenager who was just lost, or my own child coming through the window who snuck out at night, or an old man next door who just wanted to rant. You still should wait until you absolutely have no choice but to wait. But theoretically, once they come into your home, the castle doctrine kicks in, you probably be okay in that situation. But until they come into your home, the castle doctrine doesn't apply. And everybody's going to talk about curtilage. That castle doctrine applies to, your curtilage, which is like your garage, your carport, your shed in the backyard. I get all that stuff, but I'm talking about practicality here. You can tell me till you're blue in the face that curtilage counts, but my experience is that most cops and prosecutors and judges and jurors, they ain't going to go for curtilage. You can point out the statute till you're blue in the face, and maybe you win it in some sort of motion to dismiss or something. But if they're outside your home, you're going to have a problem. I'm just putting it out there. You're going to have a problem. So shooting somebody through the door is going to be a problem. It just is. Now, are there some circumstances where it might not be? Let's say it's 2:00 in the morning and you can see through the peephole that there's 4 big guys out there with ski masks on and shotguns. And one of them says through the door, if I come through here, I'm killing you and your whole family. You should obviously call 911 is the first thing you should do. In that situation, if you shot through the door, you might have a good chance of getting away with something like that. Not getting away, but being found not guilty, because those circumstances are so far in the other way that you'd be justified in doing that. But when you've got just a woman, a single woman and her 10-year-old son knocking on your door, probably doesn't have the ability to kick it in. Even if she does, it doesn't appear that the woman had a weapon or was armed or had a crowbar or anything along those lines. There was no reason for this woman not to just call 911 and stand there and let her knock on the door. It didn't appear, based on these facts, that she was in any sort of imminent fear of death or great bodily harm. And remember, that's the only time you can use deadly force or threaten use of deadly force, with the exception, of course, if they're inside your home, the castle doctrine thing that we already went over. But they're not inside the home, you're going to have to show that you were in imminent fear of death or great bodily harm. And when you just have one woman and her 10-year-old son on the outside of your door, even if they're pounding on it really hard and you're afraid it might break, as evidence in this case, you're not probably going to be justified in shooting that person. I mean, you're not. And then when you throw in all the history and everything else that went along with it, you look like the bad guy. You look like the primary aggressor in the relationship between the parties, and that's also going to not work in your favor. But even if you weren't the primary aggressor, you're still going to have a problem with it. I mean, the fact of the matter is, when somebody hasn't come inside your home, the burden of showing that you used force justifiably, it's going to be on you. I don't care what the statute says. It says that, you can file a stand your ground motion, all those kind of things, and that the burden is on the state, et cetera, et cetera. But it's a pretty low burden, and they're going to be able to meet that just based on the fact that it was an unarmed person that was still outside your home. It's going to be enough, in my opinion, for most judges to send this case to a jury, and it's going to be enough for a jury to convict you as evidence in this case. So I'm not saying, I can't give specific advice on just wait for the person to come in your home, because then people are going to go, well, that's just ridiculous because then I'm going to be in danger. My family's going to be in danger. All I'm saying is, again, hypotheticals, you can never give a straightforward answer to hypotheticals, but you can find outliers and examples of previous people's cases in order to help you come up with your decision. This case, obviously, it was clear to everybody up and down the line, law enforcement, prosecutor, judge, and jury, that this woman was not justifiable in shooting through a door and killing somebody who's on the outside of her home and didn't even make it inside the house. So this is just a lesson for you. Read up on the case if you want to. Get more of the facts if you need to. And again, just be wary and just know that whenever you use a firearm in a self-defense case, you're most likely going to get arrested. You're most likely going to get charged. And there's a high likelihood that you're going to go in front of a jury. And if you do, the facts better be on your side. And if the facts aren't on your side, like they weren't in this lady's case, you're going to end up with a conviction. So thanks for watching. If you have any questions, comments, feel free to put them down in below. Like, share, subscribe to the channel. In the meantime, as always, stay safe, stay healthy, stay vigilant, and carry on.